Hi everyone, my name is Dylan Grant and welcome to my presentation on Ontario Superior Court of Justice, Motion Record and Order. This is part 4 of my presentation, okay? I did not respond to the deception of Neymark Law Firm and the motion or order filed in the court to be released from Manulife Insurance Company and Mobility Inc. My long-term disability and wrongful dismissal cases were never reviewed by Neymark Law Firm since retained on July 26, 2019. That meant that I had no obligation in attending anything or responding to anything. Am I correct? Yeah. Okay. I believe I'm correct. Please see details on the discrimination deception of Neymark Law on the reason why I did not respond to the order. Neymark Law was intentional when they held on to all my cases and did their own thing to cover for all the other entities. Okay? Since I retained Neymark Law, I was being misled to delay my cases. And I'm sure you will agree with what I said, okay? Yeah. The following documents that were filed in the court of law had opened my eyes even more to the deception of Neymark Law Firm. Motion filed in the Superior Court of Justice against me in 2021. Please compare and see the deception of Neymark Law Firm. I believe you would remember these two, okay? I brought it forward in two presentations prior, okay? When I realized what really happened, I brought it forward then. Now here it is. All right. Remember, Benjamin Law has scheduled the examination for discovery long-term disability for August 16, 2019. Because I was coerced to transfer all my cases to Neymark Law in July, right? And eventually I moved all my cases over, including long-term disability. It is obvious that the examination for discovery for August 16, 2019 would be cancelled. All right. However, seeing that it was ready for examination for discovery, right? I would believe that Neymark Law would reschedule maybe 3-4 months later, right? Okay, waiting for the rescheduled letter, right? But instead, I got a letter, and as you can see, dated September 26, 2019. All right. 2 months after retain. Okay, and the letter stated that it was Grant versus Bell Mobility Inc. Date of loss May 24, 2018. This definitely meant that they were talking about the wrongful dismissal case. All right, and that it was scheduled for Friday, May 15, 2020. Okay, and therefore, since retained in July 2020, I will have to wait 10 months, okay? 10 months for the wrongful dismissal, okay? And I didn't really like that, but okay, what could I do, right? Still waiting for the long-term disability, waiting, okay? When I actually found it out was in 2022. What happened? Because if you notice, I'm sure we went through Neymark Law and you see what had happened, right? That's why I brought it forward. So my long-term disability examination for discovery was actually scheduled by the court for May 15, 2020. Can you see that, right? It says examination for discovery, Manulife Insurance and Industrial Line, long-term disability. This is long-term disability, right? And so the Superior Court had it for May 15, 2020, as you can see. Yet, Neymark Law Firm informed me that it was Bell Mobility Inc. Date of loss May 2024, 2018 for wrongful dismissal. So while they are telling me this, That's name mark law. The lawyer was supposed to be competent. Were they incompetent, or were they trying to delay my case? If they were incompetent or trying to delay my case, I do not want this lawyer. This lawyer is not good at all. That's what I would say. Either which way, they're not good, because they're not on top of things. The court has long-term disability. Why are you telling me wrongful dismissal? You see that? All right. Okay, move on. Okay, we went through this. Proof. Okay. How I was misled. Court had it on October 3rd, 2019, that it was manufacturer's life, while the letter that I received, okay, at the date of September 26, 2019. Okay, Grant versus Bell Mobility. All right, please feel free to review. Thank you. And then they didn't do anything. They just wanted to delay my case, and I just believe it was actually they were trying to deceive more than anything else. So they said, oh, because of COVID, the defense did not trust Zoom, so they asked that the discovery be cancelled until September. So May 6, 2020, got this. All right, Grant versus Mobility. May 20, and date of loss May 2024, 2018, and it says it was rescheduled for the examination for discovery, that is, right? Rescheduled for September 29, 2020, as you can see. All right. If they were actually working on my cases or had my interest at heart, wouldn't they, for between the 10 months there, wouldn't they recognize that they had the wrong thing? They had the wrong information. Okay. So what the court had manufacturer's life insurance, long-term disability, okay, and the date was September 29, 2020. All right. Say no, definitely. The client for name mark law was told as wrongful dismissal, right? While the court had long-term disability. The wrongful dismissal was on hold. I got fired in 2018 and wrongful dismissal was on hold. So nothing was done because of the damages I had on Bell Mobility. So they're trying their best. So this was false information, false communication to hold off. All right, please feel free to review. And as you can see, May 6th, the court, this is court information. All right, manufacturer's life. And as I said, May 6th, I got false information. All right. Yeah. And also remember, up to May 6th, I still did not hear anything about my long-term disability examination for discovery. Name mark law had both cases, and although the examination for discovery long-term disability was cancelled on August 16, 2019, May 6, still no mention, none whatsoever. I've not met with a lawyer, and there was no mention of long-term disability. All right? Deceitful. Cancellation of the examination for discovery dated September 29, 2020, without my consent because of name mark laws, deception, or negligence. You see, they keep putting things off, eh? Keep putting things off because they did not intend to deal with it. Guess they're trying to frustrate more than anything else. Okay. And as you can recall, breach of contract, they cancel without my consent. As breach of their own contract, because client supposed to make all critical decision, and my decision was no, do not cancel. She said, oh, she's worried that that I'm not prepared, or what. They have not prepared me. I knew my case. I could recite it actually, so no one could actually take me off guard. But what the lawyer did, that's why she didn't want to, name mark law didn't want me to go, because name mark law made a lot of changes. And because of that, they haven't met with me, and I didn't know what they did. Up to this day, I don't know what they did. Well, some came out in the court, yes. Some came out, but eventually I realized that they had taken out quite a few damaging information, including my medical record, which has been distorted. Okay, and I would guess that it is still distorted at the Ministry of Health. They had to remove that, eh? They'll have to remove that. Please feel free to review. Thank you. Better view of it, as it says. The firm will not, however, make decisions of the client in relation to resolution. The client hereby acknowledges that it will make all critical decisions with respect to resolving their their claims. Name mark law supposed to make non-critical decision, and this was in a contract. All right. See, they have a contract, and they didn't go by their contract. They know the law, the rules of procedure or something like that, and they're not going by it. Okay? Why are they lawyers, eh? One of several breaches, okay, as I said, this is a contract. Yeah, part of the contract. That is a client to make critical decisions. All right? And here, December 17, 2020, Courtney Madison, Samantha sent you the affidavits of documents for LTD and wrongful dismissal on Monday, right? The lawyer, I didn't know anything about affidavit. If her tongue didn't slip, I tell you, she forgot that she didn't tell me about affidavit. So it's not my case. It's theirs. They were doing their thing, eh? Yeah. So that's when I realized that, based off when she was speaking with me in September, Courtney that is, I realized that she said there are things that weren't relevant and that. So yeah, and when I saw the affidavit, I realized quite a few important information, including the report from distorted report from Minister of Health was not included. Okay, and a lot of other documents. There was no police report for the second accident as if it didn't happen. You understand? And all that. Wow. Please feel free to read and review. Okay, thank you. Long-term disability case, motion record. Name-mark law was retained initially for the motor vehicle accidents 2019, which had no statements of claim. 2 years later, and was denied counsel in 2021. Okay, you agree with me because you saw that. Okay, Name-mark law firm did not have any history, no communications of my long-term disability case, Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Services Inc. After they took my case from Benjamin Law Firm. No trail, no communication, nothing for over a year. Okay. Their main duty was to put a stop to the examination for discovery, which was scheduled on August 16, 2019 by Benjamin Law. That is so evident. Yeah. Okay. The deception of the lawyers, Morley Law Firm and others. Due to deception of the legal system, they were unable to keep a lie on par. There are motions and orders for used interchangeably, right? The Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Services Inc. and the Mobility, that's the combined statement of claim. And then there's another one, the Manufacturers Life Insurance Company and Industrial Alliance Insurance and Financial Services too. And there's one, Industrial Alliance Insurance and Financial Services Inc. 3. I'm talking about long-term disability. I could also include mobility, but that's on its own. So for the long-term disability, this is how they were trying to confuse the matter. Okay. The statement of claim, right? 2 statement of claim that I saw was 1 and 2 here. Okay, the combined and this one that was created initially in January by Nicolini Law, right? This first one here was created by Nicolini Law in May of 2019. Okay, please feel free to review. All right, but just letting you know that these 3, as I go along, they are used interchangeably because they are confused. All right. First exception accepted by the court of law. No statement of claim existed on its own further below. Where are the details of this lawsuit? Industrial Alliance Insurance and Financial Services. This number belongs to a combined Manulife Insurance and Industrial Alliance Insurance and Financial Services. Okay. As you can see here, letter dated June 8, 2021 indicated Grant versus Bell. Number ending in 2786 belongs to Manulife Insurance. Okay? It says Grant versus Bell, but the 2786 belongs to Manulife Insurance Company. Please feel free to review. 2786, it says Grant versus Bell. All right, this 2786 belongs to Manulife Insurance Company. All right, please find attached Miss Timble correspondent of today's date with regards to the above noted matter. So this should have just been cancelled out. It should cancel because the letter here, you see that 2786. This is in a PDF form. This is it here. Letter dated June 8, 2021. Obtained from PDF attachment. This is a PDF, right? Indicated Denning Grant versus Industrial Alliance. The Name-Mark Law knew that I was suing Industrial Alliance for. Okay, sorry. Did Name-Mark Law knew what I was suing Industrial Alliance for? Because nothing we've ever mentioned. I don't know. We never had that discussion. It was never separate on the false statement of claim. All right, and it was never in the body of the statement of claim. So what was it? Why is it singled out now? Huh? You see, they took me for a ride, eh? They put them together, and I know they're supposed to be separate. And at the court of law, they separated it. Huh? Not really, actually. It's when after the motion, after everything, they separated it. That's what they did, after everything. Because all along, when the order went out, the motion and the order went out, they were all combined. Now, when they are dealing with me, they are separating it. Okay, so as I said, the 2786 here, what it says Industrial Alliance, this 2786 belongs to Manulife. It's Manulife. Okay, Manulife Insurance. All right, Manulife Insurance is not mentioned here. Okay, although they have it here, 2786 Grant versus Bell. You see how they are confusing? All right. Anyway, I'm gonna try to let you understand what's going on. All right, oh brother. So I got a letter, and it says, as you're aware, we represent the defendant in the above noted matter. Further to our correspondence to your attention dated May 12, 2021, we were required by court order to having new legal counsel. Oh, that I should get new legal counsel by May 28, 2021, or to have confirmed that you would be representing yourself going forward. I could. What guess what happened if I did? Maybe my life put my life in more danger, because they would try to maybe even hire a hitman or something. Yeah, because they did get for the hit and run car accident and for the 3-car accident. Yeah, they have been doing things. So no, not trusting them. So no. Okay, please feel free to read if you can. Amy or Timble. So they're waiting for me to. I guess the deadline had passed, because the deadline was May 28, 2021, that I should get a new lawyer. Okay, please feel free to review. Thank you. A separate letter for Industrial Alliance. Okay. Why did I receive a separate letter for Industrial Alliance when this company was never made mentioned on its own? throughout the statement of claim or motion from the court of law? Can anyone answer that? I already said if I had anything to do with my case, my cases would have been separated. It would have been Industrial Alliance for long-term disability. It would be Money Life Insurance for short-term disability and damages, and it would be Bell Mobility for damages. So you see, these lawyers are trying to be smart, eh? So they put it on their own. The deception of the legal system. Please note that this letter from Morley Law stated Delane versus Industrial Alliance. Throughout all my presentation, you have never seen that. So why are we seeing it now? Okay. Second deception accepted by the court of law. As per Courtney Madison Neymark law, right, Bell proposed that they want to divide up your examination into wrongful and disability examinations. The Manufacturers Life Insurance Company and Industrial Alliance Insurance Company and Financial Inc. and the Bell Mobility Inc. So here they combined it. All right, they had combined it, but in September, they combined it in May 2019, and then in September 2020. I was told by Courtney that Bell proposed that they want to divide it up. Huh? So why did they combine it in the first place? To deceive, to prolong my case, because they realized I had them cornered, and they would try everything possible to ensure that what I have will not reach the court of law. Okay, please feel free to review as you go along. Okay, thank you. Again, you're all familiar with this. They are the ones who combine it. It says here, remember, it says our office was in the process of amending the LTD statement of claim to include Bell Canada as a defendant. We received consent February 28, 2019 from Defense Counsel. All right? Okay. Please feel free to review again. Thank you. All this. Monday, September 28, 2020, same day, email received at 2/2019. We went through this. All right, I'll go through quickly. All right, 2/29, when they said, well, proposed that they want to divide up your examination into wrongful and disability examinations, as you can see there. Okay. A combined statement of claim for both insurance companies and Bell Mobility Inc. submitted as a motion. The combined, eh? Why was it submitted? Why the combined statement, which basically was not a part of that letter that Neymark Law said they weren't going to represent me anymore, and then it shouldn't have been created anyway, right? It says here, combine a year prior without my knowledge, July 2019. Neymark Law stated that actually from May, right? But Neymark Law got it certified in July 2019. It wasn't certified, right? Neymark Law stated that the defense did not want them combined but separate in September 2020. Why was the combined statement of claim submitted as a motion 2021? Why was it if it should not have been combined? Yeah? I, the client, would not have agreed to a combined statement of claim. These activities through the court of law are null and void. Wouldn't you think? All right? So here, affidavit of Amy Timble. They said they didn't want this thing combined, and yet still they have combined it here. As I see it, Manufacturers Life and including Bell Mobility Inc. All right. So it Amy Timble. I didn't even see. I'm not sure. Should I have received this? I think the affidavit, right? To the so the Ontario Superior Court of Justice got this from Amy Timble, right? Amy Timble of the town of Oakville in the regional municipality of Halton make oath to say, I'm a partner with the firm of Hicks Morley Law. All right? Hicks Morley Hamilton Stewart Stork, I guess, LLP. Anyway, 2, it says the defendant Bell Mobility Inc. is a wholly owned subsidiary of Bell Canada collectively. All right. And then here, please feel free to read as you go along. She said here, the plaintiff amended her statement of claim. The plaintiff, what lies, eh? Where's my copy? The plaintiff amended the statement of claim to add Bell as a defendant in and around June 2019. The plaintiff, so Adrian Nicolini acted as me, he's the plaintiff, not me, to add Bell as the defendant. No, it wasn't June, it was May. It was May 2019, okay? And wow, and a lot of things here. Please feel free to read my doodle, but you do understand what has been going on and that I was cheated by the system. All right? Please feel free to review. Thank you. Okay, the plaintiff was Nicolini Law Firm, which acted, okay, without my consent, as you can see. And please feel free to read. This motion cannot be me. If I had no involvement in the exception of Nicolini Law, because they keep saying the plaintiff. In addition to the within action, the plaintiff has initiated 5 additional proceedings, 2 civil claims against mobility, commenced in Brampton, and I did not do that. I did not. Okay, one time, and it was with some fruit of marking law. Once, the plaintiff first brought a civil action in Brampton, bearing court file number whatever for wrongful dismissal against Bell Canada on July 3rd, 2018. No, that is Nicolini Law impersonating me. Okay, feel free to review what should be done to Nicolini Law. If somebody pretended to be you and forged your signature and everything and acted to be you, what should happen, eh? Right? At the commencement of the litigation, the plaintiff was represented by Adrian Nicolini of Yunnan Nicolini Law Group. Yeah? That's a lie. Did not sign a contract or any statement of claims with this law firm. Okay? So it's there in writing. It's there in writing. All right? Please feel free to review. Thank you. Please feel free to read. All right? There's nonsense because I have nothing to do with it. So it doesn't make sense. I didn't really read through everything. Okay? Please feel free to read. Didn't read through everything. But whatever you read, there's some stuff here. As I said, it doesn't pertain to me. I was not involved, so it doesn't really interest me because it's gonna be pure nonsense and it's false information. Okay, please feel free to read. Thank you. Third exception accepted by the Court of Law. The statement of claim does not contain the reasons why I am suing Money Life Insurance, the Manufacturers Life Insurance Company, and Industrial Alliance Insurance and Financial Services, Inc. This was the original statement of claim that was falsely created by Nicolini Law Firm, Adrian Nicolini and Ashlyn Steels, in January 2019. All right? That's when first time I ever heard or seen statement of claim. All right, please feel free to review as I go along. Thank you. So June 11, 2021, right? That's when they brought it in. This is from Jacqueline Hallett. Okay, all this from the motion, eh? Okay. Oh, it says to Delane. All right, Jacqueline Hallett of Fixed Morley Law. Okay. And Amy Timble was included. Okay, it says, please find attached Miss Timble's correspondence of today's date with regards to the above noted matter. So this is saying 202 Grant versus Bell Mobility. They're so confused, I tell you. Grant versus Bell Mobility. All right, as you can see here. Okay, I will open that letter, let you see what's it, I guess on the next slide, okay? Here it is. I am very sure that the court filed for statement of claim, which included Industrial Alliance created without my consent, indicated 2786 and not 2202. right? 0202 belongs to Bear Mobility. What a confusion. So you see that letter said Bear Mobility, eh? You saw it. Please go back and look at it. And when I opened the attachment, this was what was within the attachment. Aren't these people confused? I think I could be a lawyer, you know. I did very well in school. I did very well in school. But I didn't want to be a lawyer. But I remember at work, many of my friends said, Delaney, your skills are not being utilized. I was everything. I investigate, I solve problems. From Jamaica here to Canada. You understand? And what? They think people are foolish. I have common sense. I can read and understand. So they are confused. And I will tell you, when I was in school here, you see, myself and this other person, this other girl from Jamaica, right? We used to do the work, and others who are not of our or a different nationality, different race, used to, when we were placed in group, they always wanted to know which class we're going to do next, because they didn't do the work. But the other girl and I, right, did all the work, and we have been getting A's, right, for our group project, for our group, right? And you realize that we as black people would not, if we went for a job, if all of us out of the group went for a job, they would take the other race over us, and we are the ones who did the work. So in a case like this, you can see, did this person really do the work when they were in school? They should be on top of things. They're making too many errors. Here it's showing Industrial Alliance, right? 202 is Bell Mobility. 2786 is Industrial Alliance. You notice a different information again for Industrial Alliance. And here it says Manulife Insurance. You know, it's supposed to be 2786. You understand? You see the confusion? Yeah? The confusion. This is supposed to be 2786. Manulife Insurance and Industrial Alliance. Feel free to review. Court order for May 12, 2021 was for Bell Mobility Inc. and not Industrial Alliance. These lawyers are unable to keep their lies straight. Okay? Please feel free to review. Okay? Letter again from Jacqueline. Okay? And it's stated, it says here, request for short motion, date, grant versus the Manulife Insurance Company, and see the file number 2786. All right. The matter of grant versus manufacturer life insurance, 2786. Provided all materials and confirmation forms been filed pursuant to the latest notice of the profession, and the matter will proceed. Yeah. They're supposed to be dealing with long-term disability. Manufacturers' life insurance, they have, but it should not be. But that was on a statement of claim. All right. I'm supposed to be only dealing with Industrial Alliance, but these lawyers did their thing and confused the case on everything. All right. And they still include Bell with the wrong number and all that. It's just confusing. Please feel free to review. Thank you. What was this all about? What are the details of Industrial Alliance? Why a separate letter? So I keep getting, so here again, Jacqueline from Hicks Morley Law Forward, June 28. Please find attached from Miss Timble correspondence of today's date with regards to court file number 2786. Okay, open it again. Industrial Alliance 2786. Aren't they confused, eh? Yeah. And what am I suing in the Industrial Alliance for? What was it all about? Okay, please feel free to review. Thank you.